On the slopes of Diamond Head, this is Kapi'olani Community College. Kulia ika nu'u, strive for the highest.
Aloha. Welcome to the legal environment of business. I'm Ben Carroll. We've been working our way through the Uniform Commercial Code, the UCC. Last time we took a look at the more familiar part of that, which was banking, which you're all familiar with. Today we will be wrapping up the UCC and also talking about other creditors' remedies such as bankruptcy. Okay, but as always, we will start with our review of what we covered last time. Okay, so what is your relationship with your bank and what governs that? Okay, well, your relationship with your bank is a contractual relationship. So as a customer or depositor, you have made arrangements with the bank to handle your money. So they're also going to be your agent in that respect. And also, they're going to be your debtor because you have given them money and you are a creditor. They will be paying on your behalf. And again, we talked about that can change a little bit if they give you overdraft protection. In that case, they have loaned you money, and for at least that transaction, it reverses. But two things to remember is that your relationship with the bank is governed by the agreement you have with them with respect to how they will handle your account and what your responsibilities are. And it's also governed by the UCC in instances where it's not covered by your own contract. Okay, so what are some of the bank's duties to you, and what are some of your responsibilities back to the bank? Well, of course, as the bank is handling your money, they are responsible for making sure it's paid properly at your demand. So they will pay when they're supposed to, and it's also on their head to not pay when they're not supposed to. So we'll mention that in a minute, but they have to be sure that they are paying the right people. And so the first line of defense against someone trying to get into your account improperly is the bank itself, although, as we'll talk about, you have some responsibilities there as well. Your responsibility is basically not to write checks when you don't have funds there, and to make sure that when you receive your bank statements that you make sure that everything coming out is authorized. So if there is a problem with your account, you let them know as well. So there is obviously an information exchange going both ways, responsibilities of both. Okay, what distinguishes checks from other drafts, and what are some different types of checks? Okay, well, we talked about it. A check is a draft, and there are other types of drafts that we looked at that are used in business, but the check is the most familiar. And the things that distinguish a check is that it is on demand. So we don't use it as really so much a loan document as a cash substitute document. So a check will be paid on demand, and it is on a bank. If it's a check, it's drawn on a financial institution. Different types of checks. We're all familiar with the regular business and personal checks, and those rely on the depositor having sufficient funds to cover it, and that's where we sometimes have a problem getting NSF, not sufficient funds, coming back if we've written a check and for whatever reason the funds are not available. Okay, what should you do if your EFT card is stolen, and how does this affect your liability? So when we say EFT acronym, we're talking about electronic funds transfer. So this is your bank card, or in essence, your credit card as well. And your responsibility is that if it's lost or stolen, to let the bank know so that they can stop payment on those cards that are no longer in your control. So you recall that if you do that within 2 days, then the extent of your liability is limited to only $50. If you do it within 2 months, your potential liability jumps up to $500, but still limited if you do it within that period. If you don't let the bank know at all or until after 2 months, then your liability is whatever they can pull out of your account. If someone forges your name on a check, and this would apply to alteration as well, who's responsible for this amount? You or the bank, and why? So if a forgery, in other words, your name or an endorsement is signed, or the check is altered in some way, perhaps they've changed the amount from 10 to 100 or something of that nature, who's responsible for that payment? Well, if the bank pays that, in general, they will need to reimburse you for that amount, because the bank is considered to be the professional, the expert, and they train tellers, etc., to observe hints of forgery and that sort of thing. So it's their responsibility to make sure whoever is bringing that instrument in is the proper payee. And again, we talked about the banks aren't really regulated exactly how they do that, but of course they're getting more and more particular about it, including the thumbprints and pictures and whatever. So generally the responsibility for forgery or alteration is the bank, the expert. However, if you do something that makes it likely that the instrument can be misused, if you're negligent in how you handle or present the instrument, then you may be liable as well. And so what would that look like? Well, if you leave the payee or the amount blank, the bank is not going to be responsible. So that's clear. Every time you let a document out that is blank in those two regards, and whoever fills them in, that's going to come back on you. Another thing that we talked about, your responsibility to look at your statements and make sure that anything being paid is in fact a proper payment. So you do need to review and let them know even after the fact if something is occurring in your account that they're not supposed to. And obviously it makes sense that if somebody's regularly going into your account in this way, that you can let the bank know and they could prevent the future instances. So particularly in something reoccurring, you can see that makes sense for that to be your responsibility. Okay, what are some of the concerns with online banking, and how can we protect ourselves from fraud and phishing? Well, when we looked at the internet a while back, we saw how the anonymity on the internet, not knowing who you're dealing with, that sort of thing, obviously all applies to online banking as well. And more now, the phishers, the people committing fraud on the internet, are getting quite sophisticated, using bank logos, often using actually bank phone numbers and that sort of thing when they send you emails and indicate to you something's wrong with your account, it's frozen, that sort of thing. So very sophisticated work being done in this area. We heard some from folks telling us just some of the tips to protect ourselves from this kind of attack, so to speak. Okay, well, we're going to look at the last section of the UCC, Article 9, concerning secured transactions. We'll look at a couple of other ways that debtors and creditors interrelate and that creditors are protected in their business dealings as well. So we'll look at three main areas. We're going to look at liens, we're going to look at secured transactions, and then finally we'll look a little bit at bankruptcy. Okay, so when we have a debt, we expect to be paid, but in some instances we want some security. So in securing debt, we want perhaps some guarantee or some something to make sure that if there's a default in repaying us, that we will get our money. Okay. And we talked last time a little bit about we can have a guarantor, somebody co-sign, that sort of thing on a negotiable instrument. But sometimes we simply want some property. We want something there that we have possession of or can get possession of that will guarantee that we receive our funds. Okay, so a lien is an interest in property that the law gives us. In other words, that's by operation of law. In certain instances, we will have a lien, which means that we have an interest in property covering a repayment. So we would consider those to be non-consensual or involuntary. In other words, we don't have to agree with someone that we have a lien. the lien is in place, again, through operation of law. Okay. Now, if we come to an agreement with someone that there will be property involved to cover us, and we call that often collateral, then that contractual agreement is a security interest. So we are securing, in other words, we're protecting or guaranteeing our repayment through interest in property. And this would be consensual or voluntary because we're doing that by agreement. So the difference between a lien and a security interest is generally whether or not we have agreed to it or whether it occurs in operation of law. Okay, so this establishes, both liens and security interest establish a relationship between a debt and property or asset or collateral of the debtor. So if we are not paid at the appropriate time, we can make demand, and if we continue to not receive payment, then we are able to sell the property, have the property sold, and receive the proceeds. Okay, and you may be familiar with this. We talk about foreclosure, particularly on, say, a mortgage document. We talk about foreclosure. Okay, so again, a lien is a security interest in property created by law rather than agreement to secure a debt or obligation. And again, we said this does not need the debtor's consent because this comes into effect in situations where the law gives us that interest. And this is not covered by the UCC. So the UCC covers what we call security interests, but many of these liens, again, occur in the law outside of the UCC. And we'll look at several different kinds. The word lien is kind of generally used to mean a number of interests that attach to obligations. We're going to use it a little less broadly, and you'll see in a minute that we're referring to a couple of specific types of law. Okay, so the types of liens are what we call non-judicial, and there's a set 4 or 5 different types of liens that come into play in different business situations, and again, they are there by specific statutes, and we might call these statutory liens as well. You may hear that term. And so these liens would be, some of the examples would be a mechanic's lien, an artisan's lien, or an innkeeper's lien. And you can see that those attach to particular occupations and the dealings we have with those folks. Now, a whole other category of lien is what we call judicial liens or judgment liens, and you can tell from the sound of them, this comes from the court. So for the most part, these liens are used in recovering if we have won a judgment. So after we have a lawsuit, if we need help enforcing it, getting paid by the judgment debtor that owes us after the lawsuit, then we would use a judgment lien. And a term we hear, kind of an ancient term, is you'll hear writ. So writ is another word for a court order, but we typically in these judgment liens will hear the term writ, W-R-I-T. Okay, so mechanics lien, and in Hawaii we call that mechanics and materialmen's lien. And this really is not a mechanic, interestingly. It's also sometimes referred to as a construction lien. And this is a lien for work done on real property. So, for example, if you're having something done to your house, you would hire probably a general contractor. There'd be a number of different specialties, roofers, window people, etc. And you would be paying the general contractor, but if the general contractor did not pay the workers, in other words, did not pay subcontractors or other workers, they would have a mechanics and materialmen's lien on your property until they got paid. So you would have that interest against you, even though you had already made arrangements for someone else to pay it. They still have a lien on your property till it's paid. So you might have to clear that and then go after yourself, go after the general contractor if they had failed to make those payments to people that had worked on your place. Yeah. Okay, another lien that we have is the artisan's lien, and we call that in Hawaii the personal property lien, and also people may refer to it as a possessory lien. And the reason we say possessory lien is because this is generally working on personal property, and so the person, if you've taken it in to be fixed, they have it. So very clearly, an easy example is when you take your automobile in to be worked on and then you go to pick it up and you don't pay, they can hold on to it. So if you've taken something in to be repaired, worked on, improved, that's why it's frequently referred to as a possessory lien, because they have it and you need to pay to get it back. Kind of a no ticket, no laundry kind of thing. Okay. Okay, we have the innkeeper's lien, and in Hawaii we call that the hotel keeper's lien, and this one's kind of obvious as well. So if you have contracted with a hotel for lodging and other room service and videos, whatever, and you have not paid for that, they can take possession of your personal property that they happen to have in the hotel room and keep that until you have paid your bill. So they have a lien on your personal property. So that could be luggage, whatever. Okay. Okay, there's various other kinds of liens, and again, most of these are statutory liens provided by different statutes. So some of them actually operate out of common law as well to an extent. So the maritime liens are a whole interesting area of liens in admiralty, kind of an ancient area of the law. And we're not going to talk about these, but there's an interesting feature where people can arrest a ship. So if a ship is not paid some of its things, the ship can be arrested. Okay, and then there's tax liens, as you would imagine. The government will lien whatever if you haven't paid your taxes. There can be health care liens when people have provided emergency service or health care service and have not been paid. Workers' compensation lien, the insurer or the employer's insurer has paid workers' compensation benefits, and they may have a lien on a recovery where a wrongdoer is being paid for those injuries, perhaps as well. And then Hawaii also has a self-storage facility lien. So if you go to one of these, store all your extra stuff, storage places, and don't pay, they have a lien on your stuff. Okay. Okay, now the next area that we had talked about, kind of a broader area, is the judicial or judgment liens. And these are liens that come from the court, and they're really part of the collection process that happens if you win a judgment and the judgment debtor, the person who lost the case and is to pay, doesn't pay. So there's a number of writs we have, a number of orders of the court ordering that this property be used to pay your judgment. So the writ or the order itself is going to be directed often to personnel such as a sheriff, government personnel that will help you, assist you to get property and then sell it, or in the case of what we call garnishment, the writ or order is going to be directed to a third party who has money of the person who owes you, and you are directing them to pay you instead of the person the debtor. Okay, so first is the writ of attachment, and this is interesting because you can look into a writ of attachment when you have a lawsuit but you don't have a judgment yet. So if you convince the court that, for example, someone is going to remove property that will be necessary for you to satisfy a judgment, then the court can have that attached. Okay, this is to secure a debt that, in essence, hasn't yet been, the details haven't been proved because your lawsuit is still continuing. And just a quick aside, there's also a way of filing and attaching, in a sense, real property, indicating that we expect we're going to have a judgment and we don't want the property sold. That's called lis pendens. It means there's a suit pending, and we want to be sure that there's going to be assets to cover this judgment. So again, that's kind of in advance of the judgment, so you would need to be convincing to the court that you need to have this available when the judgment is entered. Okay. Writ of execution is after the judgment. So you already have a judgment, and you've asked for payment or tried to make arrangements to be paid your judgment, and the other side has not. So writ of execution is where you would have a sheriff or a court officer go and collect property and sell it to pay your judgment. Okay. Now, if they sold the judgment debtor's property and there was enough to pay your bills and something extra, then of course they would return that to the debtor. But if they sell it and it's not enough, the debtor is still on the hook for whatever the remainder is after that's been paid. Okay, and garnishment. A number of folks probably heard of garnishment. Garnishment is directed to a third party. So we've got a third party involved, and it's a situation where the third party has money or assets, something owing to the debtor. So the obvious example would be the bank we just talked about. So a bank has money, that the debtor's money that they're holding for the debtor. And the other instance that many folks are familiar with would be the employer, it's your job, regularly owes you your wages or your salary. So garnishment is a procedure by which we can have the court order that third person, the bank, the employer, anyone else in that kind of category, to pay that money to the creditor as opposed to the debtor. Okay, so the person that is holding the money is known as the garnishee. So that would be the bank or the employer. And so we would get a garnishment order, and we would send it to the garnishee. Okay, so we're saying this person, the court's looked at it, this person owes money to the creditor. Let us know what money you have. In other words, we're asking for with the garnishee summons, we're asking that the garnishee tell us what they have that belongs to the debtor. And so the bank and or the employer would send back a return, garnishee return, that would tell us we have X amount of money, or we regularly, the person's wages are X. And they're very careful to do this because the third party, the garnishee, if they do not respond to the court request, they can be on the hook for that money themselves. So if they went ahead after receiving the summons from the court, if they went ahead and paid that money to the debtor, knowing that there was this order out there, they might end up paying it twice. So they're pretty strict about returning those summons to the court. So, okay, once we get that, if it happens to be that it's a bank, then we can probably get whatever's there up to the amount that's owed us. So if it's an account of that type or a merchant owing or some other garnishee other than an employer, then we're probably going to be able to get what's there. Okay. Now, there may be some question if those are protected assets, for example, maybe a pension plan or Social Security benefits. There's some exceptions there. But the debtor is protected with respect to their wages. Okay, so there are some limits as to how much we can get from somebody's employer. And if you think about it, it makes sense. We don't want to kill the golden or the whatever kind goose by taking all of their wages. Who's going to work if they're not going to get paid at all? How are they going to live? So there's some limits on how much we can take out of their wages. So there's like a per pay period kind of restriction. Okay, so again, we only receive part of that, and each state, this is state law, so each state will say what percentage of what amounts. For example, of the first $100 in wages, you might get 1%. Of the next 100, you might get 2. So there'd be kind of a scale to make sure that you're getting a part, but you're leaving obviously the bulk for the debtor's use for living expenses, etc. And there is, in fact, a federal law, the Consumer Credit Protection Act, and so all of the garnishment requests altogether cannot be more than 25% of the debtor's take-home pay. So regardless of how many people have received, have judgments or against the debtor, they're still going to, the debtor will pay no more than 75% of their take-home. So again, that's to make sure that they would be worth their while to continue working and they wouldn't be destitute because of a number of judgments against them. Okay, so just kind of doing a quick recap, you can see that the statutory liens, mechanics, artisans, etc. We have the judicial liens, attachment, execution, garnishment. And next we're going to look at the UCC area. And so this is going to be what we call a security interest. So we have both Article 9 is a security interest, and we won't be talking about mortgages, but mortgages are also obviously a security interest most of you are familiar with. And that security interest with a mortgage is the real property. Okay. Now, UCC Article 9 is going to cover personal property. So you can see both of those we are obtaining collateral to cover. In the case of the mortgage, the collateral is the land. Okay, so let's take a look at the UCC Article 9. Okay. This governs any transaction intended to create a security interest in personal property or in fixtures. In fixtures, we're not going to get heavy into that definition. You can see that on the website. But these are things affixed to the land. And so if it's considered to be part of the land itself, that would be subject to a mortgage, not to UCC Article 9. If it's a fixture removable, then it would be subject. Okay. Okay, so when we look at a security interest, again, we're looking for something that secures or guarantees our payment. So this is property that's going to be available to us if somebody does not make payment or perform. So when we talk about possessory possession, that means a possessory security interest means that the secured party has already taken possession of the collateral. So they have the collateral, and it's simply a matter of keeping and selling, whereas non-possessory means that we don't have the collateral, but it has been pledged. In other words, it's been promised by our agreement that this is available to us. And since we don't have possession, we would need a security agreement that sets out the agreement with respect to the disposition of this property. And the security agreement needs to be in writing, needs to be signed by the debtor, and it needs to describe with reasonable particularity what property is available to us. So if you think about it, common sense, if we got the collateral, no problem, we got it. If we don't have it, it needs to be described, and it needs to be clear what property it is that's being pledged, that's being put up as collateral to guarantee our payment. Okay, so the different types of collateral, and again, this is set out, this is just kind of an overview of it. There's quite a listing and a chart of different possibilities here, but we basically divide this into two major categories. We talk about physical collateral, tangible collateral, and these are obviously things with your senses, touch, feel, etc. And these are things or goods. So we're talking about consumer goods, any inventory you have, equipment, that sort of thing that you can pledge and use as collateral. Okay. Now, intangible collateral, these are in many instances documents representing value, so we think immediately of our negotiable instruments are going to be intangible, and so we can use notes, that sort of thing can be pledged as collateral. Accounts receivable, contract rights, these sorts of things. Okay, and there's be some words there, Latin words, inchoate, and a bunch of other words of that type that you can look at. But we just mainly want to make a distinction between the things that we can have possession of and the documents or instruments that represent value. Okay, so default, we know this term from previously. Default means that we haven't been paid. So upon default, the secured party can take possession of the collateral, can sell the collateral or have it be sold in a reasonable manner, and apply the proceeds to the indebtedness. And again, as we talked about when we were talking about liens, you would return any surplus to the debtor, and then the debtor remains liable for any deficiency, so any amount that wasn't paid even after selling the collateral. So the collateral may not be enough for whatever reason. Hopefully, as a creditor, we would want sufficient collateral, but sometimes we got what we got. Okay. Now, when we have a security interest, we want to perfect that. And by perfect it, we mean make it evident and as inviolable as we can. And if I can go back a little bit to when we were talking copyright, I think this analogy may make sense. You recall when we got a copyright, we had a copyright automatically. Okay, so just putting it in fixed form gave us copyright protection. But you remember we had to register it. We had to put people on notice if we wanted to have more rights, if we wanted to get some statutory damages and that sort of thing. So even though we had this interest, this copyright interest, if we wanted it to have more protection and we wanted it to put everyone on notice that we have this interest, then we would register it with the Copyright Office. And when we talk about perfecting our security interest, we're talking about the same sort of thing. In other words, by perfecting our interest, we're putting people on notice, and we're also giving it a date. Just like we did with copyright, we're saying, as of this date, this is my interest. So that's what we mean by perfecting. Okay, now attachment of the interest is a first step. Attachment simply means we got it, okay, in the case of possession, or it means we have our written agreement. We have gotten our security agreement. So that's the first step in kind of if we have to prove it or use it, that's the first step. And then the perfecting is where we protect the integrity of it or we strengthen it. And again, this is the kind of putting on notice. Now, when I say putting on notice, we're putting everybody else on notice. Obviously, the debtor knows. So the perfecting doesn't really affect our relationship with the debtor. Once we've got our agreement or we got the collateral, we're good with the debtor. But this is putting all the other potential creditors on notice, because it's entirely possible that a debtor will pledge the same collateral to more than one person, and you might not know that. So you might not know that this one object has been pledged to a number of people, and so there's a lot of money supposedly tied up in this. And that's what the perfecting does, is it puts everybody on notice, and it kind of establishes where we are, whose interest is first, the priority, that sort of thing. Okay, so if we review how we perfect an interest, one method is with a financing statement. So we could file our financing statement with the appropriate state office that would now put everyone on notice that this particular collateral, this particular property is subject to this financing statement. So that's in essence putting in the information in our security agreement and saying everyone is now on notice, we filed, and again, like the copyright. Okay, possession of collateral, obviously if we have physical possession we talked about, that interest is covered. We have it, so if the debt isn't paid, then we can go through the process of selling. Okay, and when you buy consumer goods from a merchant, then we call it a PMSI, Purchase Money Security Interest, and so we have extended credit to a debtor to purchase something, and so we retain the right in those goods. That's perfected through that actual process of the selling of the goods. Okay. Now, once we've done this, once we've perfected our security interest, then we're pretty much protected that that would go with us even though it's been transferred. So if the debtor transfers that interest to other folks, then our security interest would remain effective and go with them. However, again, there is protection for innocent buyers that may not realize that they're purchasing something that has an interest. So you remember, if we harken back, we talked about when you sell something or transfer something, you're saying, I have good title, I have no liens, etc. That's one of the representations you're making. But guess what? Somebody may misrepresent and may sell to someone and not indicate to them this is subject to a security interest by someone else. So those innocent buyers Again, this kind of reminds us a little bit of when we were talking about holders in due course. So this innocent buyer of something that has a security interest in it, called a buyer in the ordinary course of business, may take it free of that security interest. So we're going to protect that innocent person. And we're going to do that even if that's a perfected security interest. In other words, as long as they're in good faith and they buy for value, then they are going to be protected regardless of your security interest. So there's some instances where we've done as good a job as we can perfecting our interest, and yet an innocent third party is going to be protected. Okay, now we're going to get into the area where we have more problems than not just one debt, generally. So we're going to talk a little bit about the federal bankruptcy law. Now, first thing to remember is bankruptcy is federal, okay? And as in a couple of the other areas we've looked at, it's actually in the Constitution. So the Constitution indicates that Congress has the power to establish a uniform law of bankruptcy throughout the United States. So there's no such thing as state bankruptcy. Any bankruptcy is filed with the federal government in federal court, and so we have a uniform law across the country. Okay. Now the primary purpose of bankruptcy. When we think of bankruptcy, what do we think about? Well, typically we think we got more debt than we have assets, and that's essentially what it is. But bankruptcy is there for people that have kind of in good faith or honestly gotten into trouble and can't get out. Okay, so we're going to there are going to be a lot of provisions to protect people that are trying to take advantage of the system or commit fraud or other types of things. So, but there are instances where people get into trouble, can't get out, and so this is a way of kind of giving them a fresh start. Okay, I think we talked a little bit about in the ancient times where there was actually debtor's prison. So we're past that, and again, this is an instance to allow them to get back into, take charge of their life a little bit. Now, the other thing we're trying to do, obviously, with the bankruptcy law is we're trying to do as good a job as we can of making sure that the creditors get the best deal they can as well. Obviously, if somebody goes into bankruptcy, a lot of the creditors aren't going to get paid what they're owed because there's more owed than there is asset. But we want to treat the creditors equally. We want to do as fair a job as we can and be orderly about this. We'll hear we don't want creditors rushing to the courthouse, first come, first served, so that we want to have some kind of orderly system to pay off the creditors of a debtor. Okay, so the bankruptcy code, this should remind us a little bit of the UCC, whole bunch of different sections. So chapters here, and we will use the titles when we refer to a particular kind of bankruptcy. So we will refer to a Chapter X bankruptcy because the titles, for the most part, will tell us, cover a particular type of bankruptcy. And just as we did with the UCC, we're going to focus in on a couple of the major areas. So main one is the first three chapters, and you can see 1, 3, and 5 are the first three. I have not left out the even numbers. The bankruptcy code a couple of decades ago dumped the even numbers. So the only chapters are odd chapters. So 1, 3, and 5 are in fact the first three chapters. And you can see these are general provisions, how cases are administered, talking about debtors, creditors, and the estate. And so those are kind of the foundation for all of the distinct types. So the next, starting with Chapter 7, are particular types of bankruptcy, and 7 is one we're going to refer to. And this is by far the most common. When you hear bankruptcy, this is more often than not what we're talking about, and it's called liquidation. Okay, you can see Chapter 9 talks about municipalities. Okay, then we jump to Chapter 11, reorganization, and this is the next most common area, and many of the major corporations have gone through this. So we'll talk a little bit about that. So Chapter 11 is known as reorganization. Then we have family farmers and fishermen, Chapter 12. We won't talk about Chapter 15, which is some ancillary cross-border instances. But we will talk a little bit about Chapter 13. That has the longest name, Adjustment of Debts of an Individual with Regular Income. And I'm probably going to refer to that as repayment so that we have a shorthand way and don't get tongue-twisted trying to give that title. So you can see that the ones we're going to look at are going to be, and this should be easy to remember, okay, so just remember convenience store and Lucky Friday. So 7, 11, and 13 are our major bankruptcy categories. And that's actually the order in which we hear about them most. So again, Chapter 7 is the most common, then Chapter 11, and then a little bit on Chapter 13. Okay. So again, this just kind of illustrates that the 1, 3, and 5, the introduction, definitions, etc., how bankruptcies are administered, Chapter 3 and Chapter 5 dealing with debtors, creditors, and estate, all feed into the other categories, the specific types of bankruptcy. And you can see all of the types of bankruptcy except Chapter 7, the idea is maybe we can help this person or company, enterprise, to reorganize, to change, to take care of business, and to somehow survive. So the idea is that most of these, the person may come out of bankruptcy, the entity may come out of bankruptcy and still be functional. Okay. Now, Chapter 7, again, liquidate's a word we've heard before. Liquidate means turn into cash, and that's exactly what it means in this instance. So if it doesn't look like there's a chance that this enterprise can continue, even with help, then we will liquidate it, we'll sell everything, pay off who we can, and that's the liquidation. So another thing to remember is people can start in one of these categories and move to another. So you could start as a Chapter 11 reorganization. Things don't work out. Looks like pretty clear it's not going to happen. We're not going to be able to keep this as a going concern. Then we would move to Chapter 7. So we would then decide have to liquidate. And that, of course, has happened with some of the airlines. Hawaiian Airlines started out as Chapter 11 and ended up being liquidated. On the other hand, sometimes you could start out in liquidation and something would happen under Chapter 7, and you could say, looks like we can either move to Chapter 11 reorganization, or if an individual moved to Chapter 13 repayment. So it's possible to move between the categories if things change, or if as you find more information, it appears that something else is a better fit. Okay, so the general process, well, in bankruptcy court, and then we take these to federal court, so each federal district court also has a bankruptcy court, so there's 94, 95 of them around the country, and we would petition the bankruptcy court to start a bankruptcy. Now, a couple things about this is you can be voluntary, so that means that the debtor has decided that I don't know what to do. I'm not going to be able to keep up with my bills. The creditors are hounding me, etc., and has made a determination. I don't really have an option other than filing for bankruptcy. So that would be voluntary, meaning that I have decided to file bankruptcy. There's also involuntary bankruptcy. So it may be that my creditors, enough of them have gotten together and they petition the court saying, this person's going down the tube, we're not going to get paid maybe anything at all, but we'd like to have the court take charge and see if we can get something out of this. So in some instances, the creditors can come and say, we want the court to be involved, and the debtor may be saying, no problem, I'm fixing it just around the corner, things will be better, I don't need to file bankruptcy, my ship will come in, whatever. But the creditors can get together and cause a bankruptcy, in other words, an involuntary bankruptcy, and file that petition. Okay. Then, of course, we need to give notice to all the creditors. So some of the creditors have been involved in filing, but we need to let everybody know. So we have notice to creditors. And then we have, in most instances, a trustee is going to be appointed. So that's going to be a third party that the bankruptcy court puts in charge. And again, these are experienced people that have done this and are selected for that. Trustee is in charge, and they will essentially administer the estate of the bankrupt and make sure everything's happening properly. Now, we'll talk a little bit more when we get to the specific areas that we're not usually going to have a trustee in a reorganization. We're going to let the company that's trying to reorganize do that, and we call that debtor in possession. In other words, they stay in charge, but we'll have a creditors committee. There'll be people watching and making sure things are working properly. But in the other areas, certainly 7 and 13 and the other areas, you would have a trustee doing this. Okay, so then the bulk of the bankruptcy proceeding is the finding out where the assets are, court hearings, examining the debtor. If we've kind of put this out and there are a lot of potential creditors out there, then we'll need to have proofs of claim. So there may be people that have not, they don't have secured interest, they don't have anything on record, but they've paid money, they've purchased something. And so we'll have proof of claim where that we'll have to collect all those and see exactly how many folks we're talking about, how many debtors there are out there. Okay. Now, in the types of bankruptcy where we're trying to fix it, in other words, we're trying to reorganize or repay, then in those instances, the debtor has the first shot at coming up with a plan. In other words, here's what I expect to do that will allow me to pay people and remain a going concern. And so that plan would need to be developed. There may be opportunity for the creditors to submit other plans. Certainly the creditors, a number of them would need to approve the plan, and if it's approved, then the court would confirm a plan. Okay, and then at that point, there would be distribution. Okay, so we would figure out who gets what, and usually it's a percentage on the dollar. If it's an ongoing concern, in other words, a Chapter 11 or 13, would be arrangements. There may be payments into the future. Obviously, if it's a liquidation, that means we're selling everything and it's ending. So we would figure out who's going to be paid what. And assuming that the debtor complies with the court order, the bankruptcy court orders, and the plan, if there's a plan in effect, then they would be discharged. Okay, so discharge would mean that at that point, they're, in essence, debt-free. Okay, so. Okay, so the bankruptcy code has actually changed rather dramatically in 2005. There had been obviously a number of changes over the years. As we said, they got rid of all the even numbers, that sort of thing. But in 2005, it was kind of a bankruptcy reform act, and there were actually some more qualifications put in to qualify for bankruptcy in chapters 7, 11, 13, the ones we're talking about. And there's some requirements for debt counseling, taking classes, etc., to make sure that people take this a little more seriously, I guess. So those changes are in effect, and it really made bankruptcy, for the most part, a little bit harder and more onerous for people to file. Okay, so just look at some general features of bankruptcy. We have what we call an automatic stay, and a stay means stopping actions against the bankrupt. We have some exemptions. In other words, they're not going to take away your only residence. They're not going to. So there's some exemptions, things that are exempted from being part of your estate. Then we'll talk about a little bit how we distribute to creditors, and then finally we'll talk about discharge. In other words, at the end of the process, what do we end up with? Okay, so the automatic stay is really one of the key features that makes bankruptcy work. And what this means is actually that all of the actions against the debtor are frozen. In other words, they stop. And this is automatic. Okay, so you can't foreclose, you can't garnish, you can't use these various remedies. And the idea is until the court, the trustee, has a chance to look and see what the situation is, we're going to stop all of this activity, kind of give some breathing room. And anybody who violates this can actually be charged with contempt. So again, automatic, file the bankruptcy petition, virtually all of these actions stop. There are a few exceptions that can continue, but for the most part, all of the legal actions, all of the collection actions against a bankrupt are stopped by the automatic stay. Okay. Again, there's some minor exceptions you can see here. If there are criminal proceedings, they're revoking a license. Obviously, the tax folks are still there. You do need to keep paying your child support and that sort of thing. But for the most part, as I said, the actions are stopped. Okay, so let's look right at one of our chapters. And again, Chapter 7, liquidation, is the most common. And so any property that is non-exempt is sold for cash. In other words, that's the liquidation. We're going to sell everything with the exception of these exemptions that we're going to allow the debtor to keep. Then we give all of the cash to the creditors, and anything that was not part of this is discharged. So assuming that the debtor has gone properly through the process, at the end of it, they are, in essence, debt-free. So it is starting over. Okay, anybody, including partnerships, corporations, etc., can be debtors. So again, we said even a company trying to reorganize might end up as a Chapter 7 and be liquidated. There are some exceptions. Some types of companies cannot go through Chapter 7. And we've talked about these, a lot of them. They're the banks, credit unions, insurance companies, and historically, for some reason, railroads cannot use this. Okay, now the bankruptcy code does make sure that there is not any kind of fraud or preferences going on. So if somebody knows they're going to file bankruptcy and they start transferring stuff to other people, that sort of thing, or favoring different people, then the bankruptcy can cancel those, void those kinds of transfers. So once the bankruptcy court is in charge, they have a lot of discretionary power to make sure things are being done fairly. Okay, now another critical feature in addition to the automatic stay is the different exemptions. Okay, now there can be both state and federal exemptions. They are often very similar, and this protects certain kinds of property that does not need to be liquidated. Okay, so we'll take a look at the federal exemptions. So equity in a homestead and a burial plot, one motor vehicle, household goods, furnishings, crops, animals, etc. And again, there are dollar limits on all of these. Okay. Jewelry, tools of the debtor's trade. In other words, if someone's a carpenter, we're not going to take away their carpentry tools. Okay, life insurance contracts, and a lot of retirement kind of benefits are protected. Okay, so these are all exempt. These would not be part of the estate and would not have to be liquidated. The debtor could retain these. Okay, now when we are going to pay people finally, again, the whole idea is that with a bankruptcy, you're not going to get what you're owed. It's a given. The person does not have sufficient funds. We hope that if it's a reorganization, we might improve our lot, but with a Chapter 7, we're just going to be selling stuff. Okay, so there's a priority, and as we talked about earlier, perfecting a security interest is a good idea. It makes you higher in the priority. Okay, so the secured creditors have priority with respect to their collateral. Okay, and there are certain kinds of priority claims, by which we mean bankruptcy costs, support obligations, taxes. Then the whole unwashed is unsecured creditors, which means you're last on the list because each of these groups is going to be paid before they get to the lower group. And then finally, if you file later or some other instances, good luck. Okay, so again, this is the priority with which we're going to pay with whatever amounts are available. Okay, and at the end we discharge. So what discharge means is we're terminating the legal duty, and so if we're properly discharged, in that instance, the debtor is finished. Okay, so we can only get a discharge if we're an individual, and not all debts are dischargeable. So we'll take a look. Some of them that you cannot discharge, and these are public policy decisions, is we're not going to be able to discharge alimony, taxes, certain loans, some of our amounts we owe to employees, criminal restitution, fraud, taxes, etc. So I see we've done taxes twice, and that's because the government's going to get those. Okay, so discharge means that all the non-exempt assets are liquidated, they've been distributed, debts are now extinguished. If we have committed fraud on the court, we've lied to the bankruptcy court, or we have privately agreed that some debts will remain, then those would not be discharged. But if we have in good faith complied with our agreements and the bankruptcy orders, then we are going to be discharged. And that means we're, at that point, finished and debt-free. Okay, reorganization is trying to keep a business going. Again, it stops the actions against the creditor, and the company remains in charge. So the creditors are involved in coming up with a plan, and if it's agreed to and approved by the court, then we will continue to operate. Okay, got to pay it off in 5 years, and once it's confirmed, the plan is confirmed, then it's binding on everybody. Okay. And the last area we want to look at is repayment. This is kind of like a reorganization for individuals. It does not get rid of the debts. It simply reschedules. So it provides, again, the breathing room for somebody to make payments. It's voluntary, so people can't make you do this, and it's only for individuals. Okay, so this is somebody that doesn't want to lose the property in Chapter 7. They think they can make a deal, and they think they can get the creditors to agree. Okay, so just kind of a recap. The estate includes all of the assets that aren't exempt. Both the automatic stay and the exempt property is what makes this work, gives us breathing room. Trustee or the creditors' committees will make sure that it's all done fairly. The priorities will say who gets paid, and finally, if it's properly distributed and no fraud or anything, then you will be discharged. Okay, so we've kind of zipped through those. These are our creditor remedies. So we've touched on all of those. We are now finished with UCC. Please do take a look at the materials that we have online. Again, there's 3 areas we've covered, so there's a lot of extra exercises and information available. So please take a look at that. Next time, we're going to get together and look at agency. So we'll start looking at business relationships. We'll eventually look at corporations, partnerships, etc. But we're going to start out with agency next time. So this has Ben Carroll saying aloha. See you then.